Hello everyone and welcome back to Cipher Studios, where we cover news and discussions revolving around English language anime dubbing. Thank you all so much for being patient with us during the hiatus, but before we move on to other topics, we think we should briefly cover what could be considered one of the most intense controversies of this community that's been going on since the beginning of the year, and go over what might occur in its wake. Before even that though, let us do our best to be perfectly clear. While we do have thoughts on the industry that we cover, if you're hoping to use this video to gauge what quote side we're on, what our stance is on certain social issues, or our personal takes on any individuals, you're not going to get that here. Furthermore, while we've worked with people who may have expressed their own views on the situation at hand, those opinions do not play a part in the conception, tone, or conclusion of this video. We aim to accurately summarize the trajectory of the case itself, rather than go through every individual filing or news break, and express what effect this could tangibly have on the dubbing industry moving forward, which has always been most of our content's main focus. So, without further ado, where do we start? Well, earlier this year, Dragon Ball Super Broly, the latest film in the Dragon Ball franchise, was released in the West and is currently resting as one of the highest grossing Dragon Ball films of all time. The film is a direct sequel to the Dragon Ball Super television series that ended last year, and canonized one of the franchise's most popular characters, Broly, who, up until that point, had only made appearances in video games and a trilogy of non-canon films. Back when those films were dubbed, Vic Mignogna, who many might also recognize as the English voice for Edward Elric from Fullmetal Alchemist, was cast to portray this character in English and reprised his role for the dub of this new film. However, after hitting general Western theaters in January, controversy surrounding the actor began to spread online, as people began sharing stories ranging from describing generally uncomfortable encounters to accusations of sexual misconduct and assault, with some of the most noteworthy accusations eventually coming from fellow voice actors Monica Rial and Jamie Marchi. As this all happened, a few companies decided to act in response. Rooster Teeth, well known for their popular web series such as RWBY, cut ties with Vic, who had previously played a fan-favorite character in the form of Crow. And on February 11th, Funimation, the company currently responsible for distributing Dragon Ball in the West, put out a formal announcement that they were also cutting ties with Vic after an internal investigation. On February 13th, Vic put out a public apology for the way that he acted, mentioning that he would get some sort of help. Then, around a week later, a GoFundMe titled Vic Kicks Back was started by Minnesota lawyer and YouTube live streamer Nick Rechietta, stating the money would be for Vic's legal defense fees, which Vic supporters could donate to. Later on, Vic officially sued Monica, Jamie, Monica's fiancé Ron Toye, and Funimation for defamation, tortious interference with existing contracts, tortious interference with prospective business contracts, civil conspiracy, and an additional claim against Funimation for vicarious liability, obviously in reference to the aforementioned tweets revolving around him. In other words, it appeared that Vic was suing the defendants for making slanderous statements about him that resulted in net losses towards his overall career, while conspiring to interfere both directly and indirectly with other prospective businesses such as anime convention appearances. Now, it's important to clarify that this was not a criminal case where Vic had charges pressed against him. Rather, this was a civil case that Vic himself had brought forward as the plaintiff, meaning that he and his counsel had the burden of proving the claims brought forward. In order to prove defamation in the state of Texas, a plaintiff must demonstrate that the defendant made a false statement of fact to a third party about the plaintiff. This is important because forms of hyperbole like sarcasm, figures of speech, or even parody cannot be considered defamatory as they are protected under the First Amendment. Furthermore, if the plaintiff is ruled as a public figure or a limited purpose public figure by the court, then they need to also prove something called actual malice, which is a specific legal term that refers to a situation where the defendants made a defamatory statement fully knowing that it wasn't true but decided to say it anyway. So even if a statement turns out to be false, as long as the defendants believed it to be true at the time that it was made and believes that the actions of the plaintiff can be considered a matter of public concern, that means there is no defamation. It's not enough that someone simply says or writes something clearly with malicious intent behind it. Now, as a response to the lawsuit, all four defendants filed a motion to dismiss, saying that the case went against Chapter 27 of the Texas Citizens and Participation Act, or the Tcpa for short, which allows an individual or organization facing a frivolous lawsuit the ability to quickly resolve the issue if the case is discovered to be a SLAP. In this case, a SLAP, or Strategic Lawsuit Against Public Participation, is a lawsuit that is intended to censor, intimidate, or silence people who try to criticize or speak out by burdening them with the cost of legal defense fees. Even if a lawsuit is baseless, it could still cost individuals a lot of money and time that they simply might not have, thus forcing them to settle even if they didn't do anything wrong. The Texas legislature created the Tcpa in order to defend individuals and organizations from any lawsuits that might infringe on their constitutional rights to express their freedom of speech. To break it down and simplify, the Tcpa could be considered a three-step process. First, the defendants make a claim that the basis of bringing this lawsuit before the court was simply to intimidate and punish with a long, costly lawsuit, and that any statements and tweets that Vic's legal team filed against were First Amendment protected speech. Then the plaintiff has to present clear and specific evidence of each element of each cause of action that he is suing for. Only after that can the defendants counter with affirmative defenses, which can be used to counter or mitigate the legal consequences of the defendant's otherwise unlawful conduct. For example, in this specific case, Funimation seemed to be prepping an argument that Vic was in fact libel-proof, which would mean that even if their comments did defame him, his reputation prior to January would have already been damaged to the point where it was impossible for him to tie damages to their supposed defamatory statements. Even in defamation per se cases, where damages are presumed, the plaintiff needs to be capable of being damaged first, and Funimation could argue that Vic can't be damaged by people claiming he sexually assaulted or harassed them by asserting that he had a reputation of such conduct for so long. Vic's counsel was required to pass this stage and prove that the foundations of what he was suing for were not meritless with clear and specific evidence. Then, after both sides have made their case, it's up to a judge to decide on whether or not anything would be retained in order to continue to the next step, or the judge could dismiss each individual cause of action at their discretion. Both sides submitted their evidence, deposition from all parties involved were recorded, affidavits were submitted regarding Vic's conduct, some by other members of the industry, and news of this case began to grow throughout the months. Various YouTube personalities consistently gave their thoughts on the case as each motion was made public, lawyers on Twitter from all over began regularly commenting on the case, and several articles from news outlets outside the anime community covered the event. As I mentioned before, we're not planning to go over every individual motion and claim that was filed or even the rather toxic discourse that has evolved the longer this lawsuit has gone on. In fact, many people's lives have been severely hurt in the community due to bullying, harassment, and even doxing, which honestly played a part in why we didn't want to cover this case in the first place. However, there's been a lot of misinformation about what this case seems to actually be about, so even though we're not lawyers ourselves, we still want to help clarify that at the very least. If you want more details on this case beyond our surface summary, a Twitter user by the name of Shane Holmberg created a Google Doc with all the relevant motions and transcripts, which we'll have linked in the description down below. Eventually, the Tcpa hearing was held on September 6th under Judge John Chupp, and that hearing concluded with the judge dismissing 12 of the 17 cases at the bench, while concluding that Vic was in fact a limited-purpose public figure, and leaving Judge Chupp 30 days to rule on the remaining 5. Evidently, some people did not take well to that decision, with various threats being posted or directed towards the judge himself. As a result, on September 17th, the judge ordered for mediation of all parties involved to see if they could come to some kind of settlement. However, if mediation did not work, then Chupp announced that he would be making his ruling on October 4th. A mediation appeared to take place between all parties on October 2nd, only for them to reach an impasse, meaning that no agreement appeared to be made. Then, on October 4th, Judge Chupp ruled that the remaining 5 causes of action against the defendants were also dismissed under the Tcpa, meaning that the case in its entirety was dismissed with prejudice due to Vic's counsel failing to meet the standard of clear and specific evidence. The word prejudice in this context does not mean that the judge admits to making a biased judgment, but rather it refers to refiling the same case. If a case is dismissed without prejudice, usually for minor technical errors, the plaintiff can make those same charges and do everything over again. However, when dismissed with prejudice, there's no such do-over, and a plaintiff can no longer bring that exact lawsuit against those defendants ever again. So now, the obvious question after all of this is, where do we go from here? And that answer is going to vary depending on what or who exactly you're talking about. Because this was a civil lawsuit, Vic was not charged with any crimes in the wake of the case being dismissed. Rather, as a consequence of the case being dismissed under the Tcpa, Vic is now responsible for paying a currently unknown amount of money to the defendants in order to cover their attorney fees, while also being charged with paying additional sanctions. Both of these sums will be determined at a separate hearing that was just recently scheduled for November 21st, and are meant to deter others from making similar slap suits in the future. So as of writing this, there's no way to say for sure exactly how much money Vic will owe, or how exactly he'll pay it. However, on the same day that the hearing date was set, Vic's counsel did officially submit a notice of appeal in order to have his case reviewed by the appellate court, with the intention of having the judgment overturned. This notice doesn't really go into effect until the case is officially considered over, which doesn't happen until after the sanctions hearing. Bear in mind though, assuming the appeal moves forward, Vic will not be able to introduce any new evidence, as the appellate court would need to evaluate the case based solely on the materials that had already been filed, in addition to the transcript of the Tcpa hearing itself. It's also likely that the appellate court won't even have the time to look at this case for at least a couple of months at the absolute minimum. And as for Vic's career itself, that could also be difficult to articulate at this current juncture because despite being the one to bring this suit forward, Vic has actually made the fewest public comments about the case itself, with many of his fans continuing to be quite vocal. In fact, the aforementioned GoFundMe is still open and, at the time of this recording, is currently resting at just above $250,000. While he did have some cons cancel his appearances, he's also been invited to a few others, attending HawaiiCon the weekend before the case was dismissed. In fact, when making a case for tortious interference, one of the main contracts his lawyer argued was breached was KamehaCon, based on a series of text messages between Monica's fiance and con staff, saying that they might pull out Vic's sponsorship if they have Vic as a guest. However, not only did Vic end up attending that convention, thus nullifying any potential interference, but Ron and other guests do have a legal right to negotiate the conditions of their con appearances, as is quite common in the industry. When it comes to his job as a voice actor, that's also a little hard to judge. Regarding established characters that are bound to make an appearance in other media, Rooster Teeth has already recast Crow with Jason LeBrecq, the English voice of Dobby from My Hero Academia, Champa in Dragon Ball Super, and Hei from Darker Than Black. Some of his prior roles at Funimation have already been recast, such as Austin Tyndall now playing Rin Matsuoka in the new Free OVA, and according to a recent review of the film, Johnny Young Bosch was the voice of Sabo in One Piece Stampede. Though it'll be interesting to see the situation revolving around Broly in particular, because Vic's voice samples are obviously still in the Dragon Ball FighterZ game. Whenever a new DLC character gets added to the game, sometimes pre-existing characters will gain new encounter quotes specifically for when they fight against that new character. So for instance, Vegito was added to the game back in DLC Pack 2, and as a result, some characters like Goku Black got quotes specific to their fights against Vegito. But when Gogeta got added, then Vegito himself gained new dialogue for when the two of them would fight. So when the canon Broly gets added as DLC, not only might he be recast, but the old Broly that still has Vic's voice could potentially need additional encounter dialogue as a result, though we have no idea how the logistics of that could even potentially be handled. As for Funimation, it's clear that they haven't had the best PR during the past couple of months. Obviously, people have lobbied en masse against them for many other reasons outside this lawsuit, such as subpar visuals on physical media, lack of streaming availability abroad, or dissatisfaction with certain dubbing decisions, some of which we've actually commented on in other videos. However, in August, there was the Funny Leak situation that occurred during the course of the lawsuit. The hashtag was trending on Twitter alongside hashtag FunimationExposed or hashtag NotFunny when audio got leaked online of Dragon Ball actors saying inappropriate and offensive things as their respective characters, sometimes in extensive scenarios. Initially, we were going to make a video ourselves on the topic of behind the scenes blooper reels and point out how acting inappropriately in the booth while recording your characters isn't that uncommon even by today's standards. However, Derek Padula, author of The Tao of Dragon Ball, already put out a well-balanced and researched article that covered everything we probably would have brought up, and even some things we weren't aware of. So please check it out if you're curious. Link in the description. The main sentiment surrounding this audio being leaked, however, was that it would upset the Japanese producers at Toei Animation, who would be convinced to pull the Western distribution rights away from Funimation. On the one hand, Japanese clients can be very conscious of their property's image abroad. We've discussed in the past how Western companies have been obliged to meet their requests at the risk of losing the product. So maybe it is possible that could happen to Dragon Ball, given the precedent set by how Toei treats Team 4 Star's content. On the other hand, it's hard to see them considering pulling the rights unless Funimation was tangibly proving to be an obstacle to the company's financial success. However, no public comment on this matter from Toei has been made during these events. Funimation is still in charge of the distribution of One Piece and Dragon Ball, two significant Toei IPs, with the former having its serialized dub returning from hiatus as announced recently, while the latter finished airing on Toonami a few weeks ago. In terms of the other defendants, Funimation has continued rolling out seasonal simuldubs of both ongoing shows and new ones, while Monica and Jamie still seem to be working for the company, with Jamie actually playing the female lead in the simuldub of Cautious Hero. On the topic of earnings, according to Sony's quarterly securities report, sales had increased by about 11 billion yen, with higher entertainment revenues at Funimation listed as a contributing factor. Bear in mind that this report only covers between April 1st and June 30th. However, the fact that Funimation was mentioned at all as a contributing factor to Sony's increased sales is noteworthy considering that it's only been about 2 years since the buyout. What's more, on September 24th, Sony announced that they've combined France's Wakanim, Australia's Madman anime group, and US-based Funimation into a joint venture to be owned by Aniplex and Sony Pictures Television. According to the post on their website, under this structure, quote, Funimation will acquire and distribute anime content from Japan across this global portfolio of brands, each with deep regional expertise in serving fans. Now with a larger global footprint, the combined business will expand their 360-degree multi-channel approach to fan engagement that spans home entertainment, theatrical distribution, live events, and merchandising. As the first project of this union, Funimation was the quote exclusive streaming home of the latest installment in the Fate Grand Order series for 1 month. Then on October 5th, Fate Grand Order Absolute Demonic Front Babylonia was simulcast in the US on Funimation Now and launched on Wakanim and Madman streaming service called Anime Lab in their respective territories. Currently, we don't know how this will continue to affect global streaming at large moving forward, but this decision does leave the impression that Sony still has a lot of confidence in Funimation as a global brand. We understand that most people have their own rationale for the events that took place, but as for how the industry itself will be affected, that might not be something that takes shape until much further down the line. However, we hope we were able to clarify the overall structure of this very controversial topic, and helped properly frame its supposed effects to people who might be a bit confused, because we're not sure if we'll be reporting on something like this again anytime soon for reasons we hope are obvious, though if any major events transpire during the appeal process, we might try to cover it at our discretion. Again, the sources shown and mentioned in the video can be found in the description for further reading, and a huge thank you to our patrons for being so understanding about us covering such a loaded issue, including Reagan Senpai, JR Pictures, and Unknown Secret 1000. We look forward to covering more news coming out about the industry, and hope to help encourage healthy discussion about anime dubbing. This has been Cipher Studios, and until next time.